All right, ladies and gentlemen, thank you very much again for coming to our seminar today, International Law and Human Rights Unit's seminar. Today we have a very, very well-known and good guest and good speaker, Andreas Follesdal from the University of Oslo, and a co-director of one of the most well-known centers, research in courts, which is called Pluricourt. And I'm really, really looking forward to hearing to his presentation. Just to remind you that in a couple of weeks we have this is our second last guest speakers event this semester. And in a couple of weeks we have Paolo Cavalieri from the University of Edinburgh speaking on fake news and freedom of expression. So if you're interested, please go to our webpage. Without any further delay, I give the floor to Professor Follesdal, please.
Thank you, Konstantin, for the invitation. Thanks for coming to this presentation. It's very nice to be invited. It gives me an opportunity to present what in my mind is a sort of draft article on this topic of what can the natural law tradition contribute to international law today, and can it help address the challenges to international law? It's particularly helpful for me, sort of egoistically speaking, because I was asked by some editors of a book to write this, and what you didn't say is I'm not a lawyer, I'm a philosopher with very little knowledge about natural law and even less about international law. So it's very helpful to get the sort of quality control from you. We agreed I would first go through fairly in detail the sort of argument I thought might be helpful to answer this, and then we open for questions, suggestions, and I have to underscore, if you tell me, well, this section 3 doesn't really make sense, or you're misinterpreting, forget that, that's very helpful. So it's really very much a work in progress. And again, I have two former colleagues here, which shows how happy we are about Liverpool, and so they know that constructive criticism is always very much appreciated. And here, constructive means also section 2 isn't really worth keeping. So this is good. So and then what is my role here? So the natural law tradition, for some of you, as some of you know, is a very long tradition in the history of law, international law, of legal philosophy. But it's changed because now, unlike centuries ago, there's a lot of international law that's regulating the relationship among states, while originally the natural law tradition was dealing with issues of how should we deal with other states where there are no shared rules and there's nobody is applying them, specifying them, and so forth. So some are saying there's no longer any need to look at the natural law tradition, because we now have all this public international law that's basically replaced the natural law tradition. So basically, positive international law now does what the natural law tradition did. And in addition, they're too vague, nobody knows what they're really talking about, it's very sort of up in the air what natural law is really all about. So better just to scrap it. It was nice as a ladder, but we don't need it. Thank you very much. I want to challenge some of those claims. I want to partly argue that international positive law is possibly a value, but it hasn't really replaced the natural law tradition the way I want to suggest that it can be understood. So even though we've got now much positive international law, positive public international law, there may still be some roles for natural law theories, partly perhaps when we are looking at the challenges to international law, some call it crises of international law. And again, a footnote here. I beg the editors of this book, could you please tell me what are those crises? Because then I can sort of have something to write about. They said, no, we leave that to the authors. So please, again, this is a great chance where you could suggest these are the real crises that public international law faces. So again, scrap these. Here are the real ones. Some are saying international law is ineffective. Some are saying what the crisis is, it's not complied with. States aren't complying. Or some are saying, about partly the host country, states are leaving international law. They're withdrawing from treaties. So renationalizing sovereignty for a variety of reasons. Is that a crisis of international law? A challenge? It's not. So some are saying, well, international law is a bad solution for non-existent problems. It should really be doing something quite different. And also, international law is so indeterminate, it's so fragmented, and it needs so much interpretation by unaccountable judges who, in addition, are mainly foreigners. So they're dominated, the whole setup is dominated by Western states. So those would be a list of nominated problems of international law. But again, you may have others. I'll be begging you for some replacements to this list afterwards. So can natural law help with some of these, or are they partly rather to blame for some of these? And I want to indicate that partly they're the reason why we are stuck with some of this. So the outline of the paper and the presentation is, first I want to philosophize about somehow when we talk about natural law theories, what should we really be talking about? And I'll be talking about a subset of the tradition. And then I want to sketch some of what I take to be a charitable interpretation of the roles that natural law has actually played historically with regard to public international law. And then some criticisms that have been raised against natural law, and try to defend some of those theories against some of this criticism. And then let's go back and look at those crises and then see what can this particular narrow subset of natural law say. Okay, so that's the main line of what I want to say. But then we need to unpack what are these natural law theories? And again, some of you may have studied this. And again, all recommendations are most welcome. If we look at somehow nominees for who are natural law theorists, and there will be a quiz, I think you didn't mention that. Who are these and when did they live? So this is a historic, starting with Cicero. I mean, so this is a way old tradition, right? And these would be typical people, scholars that are mentioned. Aquinas, Orius, Grotius, Pufendorf, Vattel, and there are more white men, but these are dead. Hart is dead. Finis, Trindade is arguably a natural law theorist. And then there's one woman, Mary Ellen O'Connell. So these are all in the sort of category of natural law theorists. And they're all influenced by each other. Typically, historically, the causality goes, as political scientists will say, the causality goes this one way rather than the other. Some are called modern, some are called non-religious. There are lots of different labels. So, is there some sort of sense to be made of this? When we talk about natural law theories, what should we be thinking about? And so I come in as a philosopher saying, this is what I want to talk about when I talk about natural law. And that's, of course, then comes with luggage about this, so why do I pick one set rather than another? I'm interested in some of the shared features of some of these theories, and I'll probably signal which ones that fall outside the group that I'm interested in. Where the question is, how do we select? How do I identify what counts as natural law theory features, or the family that I'm interested in? And as partly, I'm interested in this particular issue of the challenges to current public international law. And of course, these authors, they had no interest in that topic, right? But I'm interested in that, and that's for that purpose that I'm looking critically with my radar. These are features of natural law that I find interesting. And also, I'm looking to see, I'm sort of the defense philosopher of this tradition, to somehow see, is there anything worth keeping of this for dealing with natural law, with the current crises, so-called, of public international law. And so I'm trying to find the most plausible interpretation of natural law for this purpose. But I'm not out to defend natural law, right? I'm just trying to come up with a charitable interpretation for this purpose. I'll note at some points areas where I happen to disagree with this, but that's not the main point of this. I'm not out to somehow defend it. So I'm looking then for shared features of the natural law tradition that captures some of them, these theories that are helpful for our purposes. And one of the central things that seems to be very clearly in the focus of very many of these theorists is, what is law all about? What is law? Why is it that positive law that's been decided by lawmakers, why should we obey? Why should we defer to what has been decided by the legislators, and that is somehow adjudicated by the courts? Of course, there's the fear of punishment. You'll go to jail or whatever. But is there any reason why we should obey or defer? That seems to me to be one of the central concerns of the natural law tradition. And then they go on, that's what they have to answer, right? It's not that they don't just flippantly say, so why should we care? But this is why we should care. Why is it that subjects have reasons to act in accordance with what the law is saying, or what the judges are saying, or what the legislators are saying? That makes people act differently than simply pursue their own self-interest or only the interest of their own family or something. That seems to me to be one of the central shared questions that many of these natural law theorists have. And their contribution, their response is, well, we can argue for the purpose of law on the basis of some features of human nature. There's something about human nature that is protected and promoted by law. And that's why we have reason to respect law. So there's some assumptions about the nature of human beings, features about the natural world, and of what law does, that combine to explain to us why we sometimes, not always, should defer, obey positive law. Okay, so this is the that's what I see as the central argument. So this means, of course, for those of you who know this means that Fuller, who's sometimes called a natural law theorist, is out, because he's not particularly interested in features of human nature. He's interested in features of the legal structure. And they are saying it's not just enough with hand-waving, we have a human nature that's promoted by law. We want careful arguments that this is how law helps humans, those aspects of human nature, to flourish better than it would in the absence of law. And the idea, at least from Thomas Aquinas onwards, has very often been to say, we need to have shared, agreed arguments about this. It's not enough for me to say, well, this is what I think. They're looking specifically at features of human nature, features about law, that's agreeable to those they're talking with. and then focusing on very careful arguments by their standards. Right? So that means that Vattel is not a theorist I'm interested in, because Vattel, by several scholars, one of the central people in this tradition, was not particularly interested in how you argue about this. He would typically stipulate that there are some norms that are important, but not be concerned about inconsistencies. Similarly, Tridade, who is currently known as a natural law theorist, when he works on the theoretical part, he's not particularly focused on the dilemmas or the tensions or the inconsistencies between the norms, or exactly how they're justified. So from that point of view, he's not working so much on the theory of natural law, even though he's a natural law contributor. So, on this view, a legitimate authority is explained in the following way. We defer to some authority, into law, or the state, or so forth, and so forth, because that helps promote the interests, some features of all individuals who are living under this regime. And it could be because the state or the law helps coordinate, and it reduces mistrust, it helps deal with risks, it settles disagreements, otherwise we would be quarreling or killing each other, and so forth. So those are the sorts of contributions that law or the state or any other authority makes. But it's justified as an authority only insofar as it's actually doing that work. Only insofar as it's a rational ordering of things that concern the common good as concerning these features. Okay? If it's not promoting that common good, it's no longer enjoying legitimate authority. It no longer has a claim to be obeyed. And then, again, here comes the more philosophical point. Many of these theorists were what philosophers will call perfectionists. So they were saying, if some are able innately to flourish more, then it might be correct that the state should facilitate their flourishing much more. At some point, they thought there were people who were natural slaves, who simply could not fathom. They could not reason very well. So they also were benefited by having somebody be their, take on their interests and promote them, right? Again, gender issues were rampant. Somehow women aren't able to reason to the same extent, so it's better also for women that men are in charge of their well-being. But what is quite pervasive in most of these theories is that nobody should be made worse off for the sake of others, but some will flourish more than others. So there's this sort of egalitarian, don't make anybody worse off by the authority, because that makes it unjust. So this is the sort of general argumentative outline for natural law theories as I see it. And I think that has implications for discussions about, so what should the state be in the business of doing? What's the role of law? What's the role of international law? Which has some implications for the shape of legitimate international law that merits deference. Okay? This is quite similar to what is now often talked about, a trustee understanding of the role of international courts, or a fiduciary understanding of the role of international law or courts. So, because they have authority in order to promote the interests of whoever they are acting on behalf of. Okay? Am I going through this at a too quick pace? Or is this all stuff you had with Constantine 2 years ago, so this is just boring? Okay? No? So again, philosophically speaking, these theories are saying there's some features of human beings that are worth protecting and must be respected and promoted by law. And they are objective in the quite limited sense that there are true and false claims about these features. They are not, the role of the state is not to maximize preference satisfaction. In what people feel like or what they enjoy might be quite different from what is actually in their interests. So natural law theories is clearly staking out one sort of position. Utilitarian theories that are more focused on preference satisfaction would be a different one. Right? They're saying there's something about human nature that needs to be protected, regardless sometimes of what people actually prefer. And this has some implications. So, and why is this? So, why this then is this called natural law? On this account, it's called natural law because the main topic is law, positive law, and it's called natural for a variety of reasons. Partly, the premises for these arguments are based on natural experiences and human reasoning. So it's said this is human nature, this is the nature of societies, this is the nature of law. Where the attempt then is to avoid controversial premises. But what counts as controversial will vary over time, right? Depending on our philosophy of science, what we know about biology, what we know about the possibilities of institutions, and so forth. Another reason to call it natural is that they're insisting that legal norms are, of course, creations. They're created by human beings. But that some of the justification for these legal norms is not only that they're created by human beings, but they also are promoting these natural features of humans. And some of those constraints on how we should act even hold when there are no socially agreed positive legal norms. And in addition, there are sometimes conditions for legitimate positive law. So natural law might say, in order to protect these features of human beings, there are some areas that should be regulated, right? The use of violence among people needs to be regulated because that affects, that harms, that threatens basic human flourishing. And it may then regulate some of the contents of positive international law, if it's specific enough. A third premise of this account is that the point of international law is individual human beings. So that's the point of these institutions. That's how we justify their existence, and that's why they sometimes deserve deference or compliance. But then, what counts as relevant features of human persons? Now that varies among the theories, right? Some of them would say, well, some people have more capability for flourishing, and some less, and so forth. Again, I'm throwing out this list of defining features because I want to construct some of the bare bones of a family of theories for my purposes. So one of the ways you could come back at me is to say, well, forget this third feature. There's a fourth or a fifth feature of natural law that's more helpful. Right? So that's, again, the homework for when I finish talking. So the family of natural law theories that I'm interested in for our purposes, for my purposes, you don't need to share my purposes. First of all, one of the pervasive, systematic, agreed aspects is individuals are rational, able to think, act on reasons to promote whatever goods they have. Right? Buttle is clear. The Indians in South America are rational. They have plans. They have property conceptions. They are rational human beings. So they have to be included in this community of human beings. Second, again, pervasive, we are all vulnerable. We depend on each other for flourishing and even for survival. And then a more mysterious aspect, that we are sociable. So we're not only egoistic, but partly because we're rational and vulnerable, we understand we need to be nice to each other because otherwise they're going to hit us back when we sleep. But also, we are committed as sociable human beings to constrain our egoism for the sake of others, for their own sake. So there are limits to what we can do to others. We can't sort of kill each other just for the fun of it. And there are limits for what we are prepared to do, let others do to third parties. So at some point, we have an obligation to prevent somebody torturing others. So to sort of constrain the nastiness of the world is another component that's a relevant feature of human nature.
Where does Hobbes fit into that, Andreas?
Hobbes does not fit into to this last. So Hobbes rejects the claim that we're sociable. He tries to build the case that we are only egoistic, and then the challenge is to be long-term egoistic rather than short-term. And so long-term egoistic, because we're rational and vulnerable, we should agree to constrain our violence to each other, right? But so he is sociable in this instrumental sense, but not in the broader sense that I'm saying this is the part of the natural law tradition that I'm interested in pursuing. So very, very well observed. Hobbes is not included in this. But he's then an outlier historically as well, because most of the others are saying there is this commitment to not harm others. And there's a disagreement about whether you could interpret Hobbes as also agreeing to that, but saying in a prisoner's dilemma situation that we're living in, you have to kill others before they kill you. If we could all know, if we were in an insurance game, we would understand that nobody prefers to kill each other, but it's okay. Now, very many of the different natural law theories historically will have a much more detailed list of those features, right? Finnis, one of the living natural law theorists, has a list of 7 different features. I'm not going there, right? Aesthetic experience, play, knowledge, a lot of different features. For our purposes, I'm saying let's not include that. Some of the implications of this. Now, so the implications will, of course, vary very much with which features of human beings we include, and how committed we are to somehow the equal standing of each. But we see even in H.L.A. Hart a minimum theory of natural law that he recognizes and accepts, says, well, some things are some standards are necessary for survival. Thank you, sir. But there's more than survival that's necessary. Right? There's flourishing. There's this mutual dependency. There's this mutual protection. So we find in Pufendorf a norm. Nobody should injure each other. Right? So nobody should make others worse off. And reparation may be required. Vattel argues for non-intervention within a state. People, outsiders, should not intervene in a state. But even Vattel, who's sometimes argued to be very strong on sovereignty, says, well, there are limits. If there's some horrendous injustice going on, it may be required to intervene. So humanitarian intervention would follow from sociability among several of these natural law theories. Okay, so that would be somehow, that's the sort of natural law theory that I want to work with. What are the contributions of natural law theories in general for public international law? First of all, they're concerned about this issue. Why should we defer to public international law? And where the argument would be, public international law merits deference or obedience insofar as it's necessary for promoting the various features of human beings. If it's necessary to reduce collective action problems, if it's necessary to enhance each other's rational flourishing, and where self-interest is limited by some kind of sociability constraints. Right? Nobody should be made worse off by public international law as a whole. And there should be some mechanism for protecting against abject abuse. That would be the sort of general outline of the point, the legitimate authority. So that sort of premise then informs some further roles of this tradition for public international law. It helps identify, so what are the scope conditions for law and for public international law that actually merits deference, that merits obedience by the various compliance constituencies. Where natural law theories are generally saying it's not that natural law theories, these sorts of arguments, should replace positive law, but they should guide positive law. So the role of positive law is to specify these sorts of concerns, these sorts of interests we have. Specify, help make rules of the game that enable us to promote those human features for everybody affected. And for sometimes the natural law arguments would say, so here's a problem you guys have. You should really agree on some kind of public international law or some kind of law to deal with these sorts of problems, these sorts of challenges. So that would be the sort of arguments that we often see in this tradition. We need some kind of common solution by legal means for settling certain kinds of conflicts, dealing with dispute resolution, the creation of public goods, private goods, and so forth. A third contribution of this tradition, I think, is available when we look at some of the sources of international law. And again, you know much more about this than me, but here's a stab. So first of all, I'm suggesting we can see some traces of natural law thinking in the current positive account of the sources of international law. Now that's what I want to do in this section of the presentation. So when we look at treaties that are basically state consent based, there's no problem from the point of view of these natural law theories to say, well, states need to consent in order for this to be legally binding. But it's not sufficient, because states can't consent just to anything and then claim that this merits deference. Jus cogens norms need to be respected, because even as a matter of positive law, treaties that violate jus cogens norms are not regarded even as legally valid. And those jus cogens norms, again, their content are contested beyond a certain first part of the list. Slavery, genocide, and some other violations, again, that risk harm to individuals. Again, natural law theories, these are violations of the norms of sociability. And so states cannot consent to treaties that violate those minimum norms of doing no harm. Because that harm is just so awful. When it comes to customary law, again, we find long discussions in this tradition about why should customary law bind as law. Some of the theorists, Bachtel and so forth, are saying that, well, states are basically tacitly consenting. And again, we find arguments about this today among scholars. Many have pointed out that this is empirically very implausible. It's very difficult to determine. How do you tacitly consent to something? And it runs into the same challenges as explicit consent, that it can't be the only element. Even though it may, again, be found to have to do with respecting individuals who are acting according to practices and their expectations should not be disappointed. Other aspects of customary international law where we find strong remnants from the natural law tradition is that customary international law is based partly on state practice and on states acting on the belief that they're under a legal obligation. And those two features, again, are puzzling present-day scholars, because why do those two combine in what ways to create binding, valid law? Again, here, natural law traditions are contributing to this. And we see one of the implications here is that the natural law tradition is not so focused on state consent, because that's one mechanism for specifying the norms, but it's not the only one, and it needs to be seen in context. And so from the point of view of natural law, the lack of state consent doesn't remove the bindingness of these norms. And we see that, for instance, in the fact that some treaty rules may come to bind third states, even though they clearly have never consented. They've never even tacitly consented, but it's still regarded as some kind of legally binding. We find for the general principles, again, the talk is very often about recognition by civilized nations, where again, lots of things need to be unpacked with what counts as civilized and who gets to decide this and how civilized are they. We find this reappearing. We find early expressions of this in discussions in the natural law tradition of jus gentium. And we find historically including general principles in the list of the formal sources in the discussions leading up to the Permanent Court of International Justice, where it's very clear that this is an attempt to try to capture commitment from natural law. And we see it also in some of the lists of what are general principles. Schachter has a list with 5 different components where he lists explicitly principles of justice that are founded on the very nature of man as a rational and social being. I think we could include women, though that has been contested in the history. But this is a very clear summary of a sort of natural law source. And then another area where this contributes has to do with the interpretation of public international law, where, so to speak, where law runs out. I need to either speed up or
We have 2 hours.
well, you have 2 hours, but others have, yeah. Again, the interpretation of public international law, what to do when law runs